One sentence to link continuity with yesterday. 65 is not implicated because it is not by state government. Lordship ended on this yesterday.
What do you mean 60?
65 of the Act. The Lordship ended yesterday, Malas.
That's right.
That's where you ended. That is not part of this. It's a state government situation, Malas.
Correct.
And secondly, 7 is, Malas, not part of the regulation.
7 means?
7 of the regulations is only those 5 parameters, which is not part, Malas, which doesn't include GBI. There are 2 points Lordship ended on. One other sentence on yesterday, Malas. 181, which my Lord saw, has, Malas, unlike regulation making powers, normally, a very detailed fasciculus of specified powers below that, for which I forgot to underline one part, but just come to 181. Under bracket 2, there is a ZD. So it's crossing, Malas, the alphabet by more than 1.5 times. So ZD reads thus: the terms and conditions for determination of tariff under 61. So it is linking it, boundarying it specifically to 61. That is, Malas, 1 ZD. So it is not leaving it open for tariff. And of course, our basic argument is that incentive is no part of tariff. And this Malas, tariff regulation under 61. Lordship saw that yesterday. Now, Malas, your Lordship will come to the next document, which is volume 4A 205. This is dated 1/8/2015. And, Malas, we are commissioned at or after this. After this. Not before. We are commissioned after this.
Appearing for whom?
I am appearing for an entity called Southern Power, which is a Tata Power, which is respondent 45, a wind power generator in Andhra Pradesh. TPREL. Yes.
Where is it situated?
Andhra Pradesh, wind power, where
Where
is
in
exactly?
Andhra Pradesh?
Where it, yes, sir. I'm just telling you. Just tell us.
Doesn't matter. Tell me.
Anantpuram. 100 megawatts. Anantpuram, 100 megawatts.
So what is this document of 1st of August 15?
Now this is, Malas, the first tariff order issued after the regulations have come into force. I am now showing a series of tariff orders which even post regulations did not intend to subsume GBI under tariff. That's the proposition.
Post?
This is the Andhra Pradesh Electricity Regulatory Commission order passed after the regulations had come into force.
Yes.
Including Regulation 20, Regulation 7, etc., etc. Despite there are attempts prior, Lordship has seen the earlier order where they did not subsume. Now after also, they don't subsume. Despite clear attempts. Come to this first. Opening is at 205. Come to 206. All the parameters are there. GBI is in force, but GBI is not subsumed. I cannot show a negative. At 206, there's a list. No GBI. If your Lordship sees the bottom of 206, AD,
so what's the point of estoppel, is it?
no. This is a review order. I am against an order. My learned, we have succeeded against an order which after several orders, that's a separate argument I'm coming to at the end, no power of review. You can't review beyond limitation. You cannot set aside. It completely wipes out the consistent course of practice over decades, over years, which never subsumed or intended to subsume or supposedly said that GBI comes under tariff.
So what, estoppel?
So a review order. No, so 2 arguments. One is, everybody understands it rightly to be outside of tariff. Now, if there is a direct statutory provision, there can't be estoppel. But there is no direct statutory provision. Everybody operating the provisions, not only
So
contemporary
you
expository.
are saying that in the words estoppel only, you have always understood it in this manner.
So a little different from estoppel. I wouldn't like to use the word estoppel.
You are saying you have always understood
All the actors, including the ERC, of course us, have always understood it to mean exclusive of GBI. And Malas, your Lordship doesn't have to go into the law, but I'll cite that one judgment, Malas. Contemporaneous exposito. The contemporaneous exposition has always intended to exclude it. Take out the judgment. And where you wanted to, you dealt with accelerated depreciation in just the opposite way. Please see that also at 206. 206. Why, Malas? AD is part of 7. My Lord has seen 7, Malas. Depreciation. So therefore there is a link. There is a link. Now, Malas, the next document, which I believe is my 6th document, is at page 357 of same volume 3A1. Now, next document is, Malas, the same volume 357. This is dated October 2015, 30th October. This is Malas Transco writing to the ERC. Specifically, now everything is addressed. It is not by inadvertence. Malas, how can you review suddenly? Where is the patent? It's by advertence, not inadvertence. It's the deliberation, not non-deliberation. 357. Just come straight to the relevant part at 360. 360.
Yes.
Take out the contemporary exposition. One judgment. Well known.
60 of the same volume?
No, same document. No, the same volume. Starting page is 357. Same, which you also just now used. 357. Then relevant is 360.
It's
volume 3A1. My laws may keep the same volume because Roshni has marked it earlier also. That's the...
Yes.
So this is 357. This is the Transco writing to the ERC by conscious deliberation. And a decision is a very, very important document that you may get this only by amendment, not as it exists.
At page 360.
360.
Marked all this.
Subsidy, that's why I'm saying, kindly use this volume. My Lord has marked some of this, not...
Subsidy incentive.
Yes.
Last
Subsidy or incentive, I'm grateful. On this aspect, DISCOM submit that the Honorable Commission may take into consideration of any incentive, including accelerated depreciation, while determining the tariff in this. No, see the next page. Next page this is only the request. The decision is next page. Just above 7 capacity utilization factor. I hope you also will mark that. Hence, it is requested to amend the regulations to pass on the scheme. How can you suddenly do a review order? There is no amendment. Well, one thing in passing, it's obvious, but it needs to be emphasized. Regulation 20 at the high, which is read against me, at the highest says you may take into consideration.
Yes.
This is taken into consideration after regulation 20. Again and again. They took into consideration 7, they took into consideration 20 and felt it is not included, you may have a further amendment. That's vital, Manas. That's vital. Today, by an order of review, which is otherwise impermissible in law, beyond limitation, beyond power, there is no power of review. There is well beyond limitation. It's an absolute bar. You suddenly change, Manas, 6 orders. That's the case. That's why the imperial order sets it right. Now, Manas, 361 is crucial. The next document is 364. Same volume. Commission basically says, we have noted your point, we are not giving you any relief. This is 15.
At any point of time, so all this was shown and marked.
Well, from his perspective, not my perspective. There's a vast difference for us.
I am direct.
The beauty of law is, Manas, both of us
has been noted by the commission, the later one, it is
The beauty is both of us rely on the same documents, but the perspectives are diametrically opposite. And each wants to persuade your lordship that his perspective is right.
Read later. I am to inform you. Read, go ahead.
So this is a de facto rejection. So de facto rejection. Then Malas, the other volume 4A 207. This is extremely important. I am now in operation. Tariff order relates to me. Again, no GBI. Page 207. Nothing is by inadvertence. 20 is taken into consideration. 7 is taken into consideration. They have asked by letter twice earlier. They've got rejections twice earlier. Now comes my tariff order at page 207. How can review change all this? That's the case for us. 26 March 16. Just come to the table. All the usual parameters my lord knows. There is depreciation always is to be underlined in that table. Depreciation exists. There is no GBI as before. There is no GBI as before. Now come to 208. Based on the above parameters and considering the useful life of the wind power plant as 25 years with a broad stable tariff for 25 years, which I have shown, Malas, the levelized generic preferential tariff works out to so-and-so without considering AD and so-and-so with AD. The above tariff shall be applicable for all the new wind power projects. That's me, Malas. What is commission on? Come on. So we are the new ones, Malas. So it's of immense importance, for at least my perspective, Malas, that everything is considered thrice over, argued, regulations applied, but never has GBI minus the impugned order of review, which is set right by the impugned order of the appellate tribunal, never has it been subsumed. Now, lastly, Malas, in the documentation, before I come to my written submission, then I'll end, Malas, just 4-5 pages. My PPA, just for completeness, lest it be said that 136 of the same volume. No, this is a different one. This is one volume which is different, Malas. 3 capital R. My PPA, specific to me. Three R. All PPAs in this batch at least are identical, or should we use any others also, but better to take 3R.
All documents as per the procedure were to be filed in one volume. Why did you distribute in so many volumes and you have adopted your own procedure, Shiva?
Well, I asked the same question.
What is this? If you follow the procedure,
apparently,
volume 1 is petitioner's written submissions, volume 2 is respondent.
No,
We
volume
spend so
A
much
is-
time. Volume 3 is documents, volume 4 is.
Rules and regulations are different from documents as per the circular.
well, I'm
That is why-
sorry, Your Lordship, in fact, should do something on the administrative side. It's not his fault if I may intervene. Your Lordship may do something with the administrative side. Well, as a prior circular, a couple of Chief Justices earlier made these format
Distinctions.
R, 3A, etc. That is being followed. Actually, all the documents I believe of mine could have come in 1 or 2 volumes, and all of Mr. Datar could have come in 1 more.
Actually,
The circular mandates these kind of distinctions.
Well, the same pattern was followed in all the MADA
Every
judgment.
matter it is done. This is the only case we are seeing. Nobody had this confusion.
No, no,
Circular का copy
The
लेके आना.
circular in MADA, etc. is big.
MADA, 9 judge, all you followed 3A,
It doesn't
3B.
need to be done.
R is all respondents. A
Have
is,
a look. We are only asking so that we can rectify it.
yeah.
Your Lordship may have looked into the circular because these people have to file as well.
So वो circular का copy निकालो. राकेश के पास.
It's actually in a smaller case more confusing than helpful. In MADA, it was large record, 9 judges and all that.
No, we never had a problem.
Not true with every case.
No, MADA, we followed the entire same scheme.
Yes.
Same.
We followed 5B.
Now, let's come to 136, my PPA. 31st October 2016, I am already operating and in commission or about to be commissioned. Come to page 137. at clause 5. You should go to clause 2.2 at 144, skip 137, Willis. 144, come to 144. Which are the articles? Page 144, if my lord goes to. This is to emphasize the point that the tariff is fixed and firm and stable for 25 years without GBI. That's all that I'm making the point. The wind power producers shall be paid tariff for energy delivered at the interconnection point for sale to DISCOM, which shall be firm at 484 without considering AD for a period of 25 years from the commercial operation as per APRC order. They could easily have said without considering any incentive. Somebody would have challenged that. They considered it and did not include any other incentive like GBI. Why do you read more questions? And at 154, something supposedly against me is actually in my favor, Melissa. 154. The last 3 lines. This means the incentives and conditions envisaged in the agreement, not beyond the agreement. See the last 3 lines. Any and all incentives / conditions envisaged in the articles of this agreement, not beyond, are subject to modification from time to time as per directions of ERC. In fact, your own ERC never modified it till now. And GBI is not part of the articles of this agreement in any manner whatsoever, despite 3 requests and 3 orders. Now, let's just read through 5 pages of my submissions. And I won't even read all of them. Come to my submissions in page 76. My lord directed us to file. So it's all in once. This is volume 2, Melissa. This is volume 2. Mine starts at 76. Lordship may ignore everything till 84. So 8 pages we'll skip, Melissa.
Reference to each of those documents which you have made.
Yes.
You took the same line in your written submission?
Yes.
Where are they?
That's, I'm coming straight to that. Now I'm just going to read through most of it. Just 5 pages. 84, I'm jumping from 76, where in para 2, your lordship has got Anantpuram and the details of the project. Para 2, straight to 84. Submissions are only 84 to 91 and I'll skip 2 pages in between more. I just read through slowly these pages. May I, Miller? 84. Submissions. GBI is an incentive granted by the central government over and above the tariff determined by the State Commission. GBI was introduced in 9 and subsequently extended in 13. So this your lordship may skip to the next page. This is an important point in 85, Melissa. Page 8, very important point. The GBI was introduced with a clear intent of incentivizing generation of wind energy and facilitating entry of large IPPs in the renewable energy space. Just pause here for 30 seconds, please. There are 2 or 3 facets here which are completely distorted. I would say illegally and possibly unconstitutionally. It's an object of incentivizing, 1, by the central government 2, and the generators. It is converted to a consumer focused, which was never focused. It was generator focused incentive. It is converted illegally into a consumer focused by a state government, which is a trespasser in a central incentive. That's why these 2 lines are important, Malus, of larger context. I'm going to just pause here. The central government scheme is all over India. Central government has to be all over India. You can't make a distinction between generator unless there's something special. You'll also be astonished to know Rajasthan generators, Kerala, Gujarat, 10 I've listed, all get incentives. But when one state ERC holds, the lordship makes a general central government all India incentive into a state specific incentive. These are fundamental issues, Willis. In terms of clause 2, and the GBI scheme 2013, the central government granted wind generators an incentive of 50 paisa fed into the grid for not less than maximum 10 years. Since scheme is meant for wind generators and is not distribution end consumers, this is the point I'm making. Just tell me what to read, otherwise don't read anything. Just tell. Mandates that GBI over and above the tariff cannot be factored into by the tariff. Now, these two are 4.6. Don't read it, just note it. Will you stop it here? Now, MNRE or should ask the questions and not here. But what does MNRE write? Turn to page 52 is my para 12. Turn to page 52 of volume 3A2. I can't help it, this is the way the index is, so Lordship has to go to another volume now.
We just read this, we don't need to see that.
This specifically says that the mandate of 4.6, which means GBI is over and above, should be followed. This is a central, yeah, how many times will I repeat it? Central government is saying so in writing. You don't need the central government anywhere. But this is a little important letter. Lordship may double take it, but Lordship is not seeing it. It's a stand of the central government in writing. And it relies on 4.6.
Yes.
Then, Malaz, the GBI policy has been notified in exercise of clause 7, which is of the 2009 scheme, and clause 6, which is of the 2013 scheme. Both are central government schemes. My lord has seen these two clauses. Both are central government. Pages are given. Therefore, the GBI scheme has been notified in exercise of the constitutional powers of executive power, 73-77. It is well settled that executive power is co-extensive with legislative powers. Neither the Electricity Act nor the rules and regulation confer any overriding powers on the state. Pause here, Manoj. I know Lordship heard Appropriation Act yesterday. There's another principle which Mr. Chidambaram did not argue, which your Lordship is well aware of. Ram Jamaya onwards. Executive power is co-extensive with legislative power. Now, executive power, unless it is inhibited by some statutory curtailment, is co-extensive with central government legislative power. This goes in parallel with the appropriation argument. Who are you? You are a central government. What have you done? You have exercised executive power given these clauses and schemes. There is no inhibiting central act. There is no inhibiting central act. You are doing violence beyond what is just the narrower compass of the case.
Okay.
Then the GBI, now this part has been covered, Malas. This is the Appropriation Act paragraph, para 14. Your Lordship may skip it. This is directly the Appropriation Act point. I am deliberately saving your Lordship's time, not reading it. It's been covered yesterday.
You can come to 7.
And I will skip, Malas, 15 to 20. Malas, I'm sorry, just see 15 and 16. Then I'll skip 20.
It's a good point. Noted.
Very well. Then 16. Just give me a minute. I'll skip from 17 a few paras, Malas. Two things are clear. In order to bring down the cost of RE for the benefit of end consumers, the central government decided to provide low-cost finance by providing low-interest-bearing funds to IREDA. You can't mix up, Malas. I'm not against consumers. They gave a separate incentive for consumers. To incentivize me, they introduced GBI. GBI is not a consumer-centric. It is not meant to reduce the cost of renewable energy for distribution licenses. You're completely putting on its head something meant for X, putting for Y. APRC order, that's the impugned order, Malas, which is set right by the final impugned order. Then, Malas, I skip till para 20. Just come to page 88. Only 3 pages are left, Malas. Just come to this is covered, but just see 3 lines, although covered, at page 88 top. Therefore, learned APRC's interpretation of Regulation 20 to claw away at a central government incentive for the benefit of end consumers makes it contrary and ultra vires the Act. Regulation 20 ought to be read down. I am saying not even read down, but read reasonably. It doesn't cover. It's limited to 7. Such a regulation must be ignored, irrespective of whether it is under challenge in the present proceedings or not. In this regard, TPRL relies on this Honorable Court's judgment. Now, Malas, we don't need to go to challenges. Your Lordship told why you're not validity, etc. Your Lordship is to read it. So, read up, read down, but read reasonably. Then, para 21. This, Malas, will be skipped because this is a sequence of the documents I just showed, para 21. But it's important only for without reading it, brothers. It is repetitive. It starts from before 15, in 15 2 or 3 times, then in 16. A to E, your lordship may kindly take all the documents in sequence, before me and after me, before 20 and with 20, before 7 and with 7, take the same stand. You can't suddenly have a review idea which is different, brothers. That is really very inconsistent. Now, this is important. Para 22, page 89 to 91 is extremely important in law. I am pressing it strongly as an alternative, brothers, completely. It's not to be taken lightly, because this is also unknown to law what has happened, brothers. I'll just read the last 2 pages, brothers, 89 to 91. APRC cannot review, amend, redetermine, and that too retrospectively, that too without limitation. Just mark this point, brothers. In terms of APRC's conduct of business regulations, APRC is empowered to review its orders either suo motu or on an application within 90 days. That's regulation 49. No power has been retained by learned APRC to review its orders after the specified period of limitation. Further, the said regulations do not empower APRC to condone the delay in reviewing its orders. So, no condonation power. Therefore, APRC has no power. Now, your lordship is not a constitutional court at the APRC level, Maris. There is no inherent power. In the present case, the appellants did not challenge the tariff order of 26th March 16. They did not seek to review the said tariff order within the prescribed period. Tariff order of March 16 attained finality. Could not have been reviewed, challenged through the GBI petition, that too much after the period of limitation. Much after, Maris. Further, the appellants could not have challenged the tariff orders of August and March in collateral proceedings. Orders have attained finality. This is barred by law. Sharma's case is cited, paras are cited. Could not have taken recourse to inherent power. This is very important, Malas. Powers are 22, deviation from norm, power to relax, issue of order. None of them, Malads, gives a power for substantively changing the concept. Not one of them. See the middle of para 24. Under the guise of exercising these powers, APRC cannot take recourse to exercise of a power, procedure for which is otherwise specifically provided. In other words, APRC could not have exercised this power to overcome the statutory bar of exercising review jurisdiction after expiry of 90 days. But the 5 powers on the top, your lordship will note it. They are not powers to relax and all, not powers to create a substantive right to GBI. Well, as for a statutory or a creature of statute, the case law is page 90. You must remember that you are a creature of statute. You cannot have malice beyond that. Then para 25 is retrospectivity. APRC order of 28-7 has the effect of this is the impugned order which is corrected by the final impugned order. Has the effect of retrospectively redetermining, reviewing the tariff determined in the tariff order of 2016. Against 90 days, 2 years. APRC does not have any power to retrospectively redetermine tariff orders. No powers have been retained by APRC in this regard in its tariff regulations. In terms of regulation 1P, Malus P, the useful life is 25 years. The proviso to regulation 4 provides that tariff shall continue for the entire, it's a stable fixed tariff. It's not a changeable, you can't tinker. Then it provides tariff is equal to useful life. The PPA between Tatas and the appellant has fixed the tariff in 2.2 for 25 years, which you just now saw with me, 2.2. Without mentioning that the same is subject to periodic review. 7 deals with the duration of agreement and specifically mentions it should be for 25 years. Therefore, PPA tariff is firm and fixed, which includes the useful life. Then lastly, I go to the last page. Order of 28-7 results in implementation of a central scheme. This is very serious, but just see the effect. You are also going to decide in a vacuum and an ivory tower. This also has to be taken into account. How will you operate a central scheme like this? Just see the consequence. MNRE in its letter of 5/7/17. That's why MNRE is concerned. Page 52. Kerala ERC, Rajasthan ERC, Gujarat ERC, Maharashtra ERC have all followed the scheme of the GBI. In fact, every other state. As a result, and they're all identical. As a result, wind generators in Andhra are not getting any GBI benefit, whereas wind generators in Karnataka, Rajasthan, Gujarat and Maharashtra are getting the benefit of GBI. That's what happens when you state level interfere with the central scheme. Uniformity, consistency. Then last parameter is 28, regulatory certainty and doctrine of legitimate expectation. Now I know the Lordship can displace legitimate expectation by specific statutory mandate. But is it not my expectation, or for that matter, all of us in Andhra Pradesh, that we will get the GBI like everybody else? And is it not certain and stable to do so? That's the last parameter. It implemented the GBI scheme as intended by not factoring GBI. Then it suddenly did a volte-face and expropriated GBI from mid developers to pass it on to as a transfer, Malas. And it's not a transfer from rich to poor. It's a strange transfer without any acquiring or expropriating act by Parliament from one public interest activity of generation, where the nature of the incentive is totally different, should be different, is different, to another category of people who have their own incentives, consumers. The central government has to take a macro all India look. For a macro all India look, they need to balance the interests of both generators and consumers. So that Sunil Krishna Khaitan's case, a regulator must act in a consistent and predictable manner. Regularity and predictability along with certainty are the hallmarks of good regulation. In fact, that's why regulators are got in, so that you don't have a state government vicissitude, individual. Tatas have invested in Andhra by setting up wind project on the assurance that it is entitled to GBI benefit over and above tariff. Again, a form of promissory estoppel. I'm not saying that if your Lordship has a direct provision saying no, but not like this. I should get 5.34, which includes GBI. Now you are saying, sorry, 5.34 will become 4 point something because GBI is out. I'm deeply obliged. Would my lords like us to put just my submission documents in a separate file, or your Lordship will go in through these different files? I can pluck them out and put them together. It's only I asked my learned friend. He says circular mandates me. So therefore,
there's more than enough. Your written submission substantially covers everything. Already the existing
84 to 91. Deeply obliged.
Completely covers. Completely.
Very deeply obliged.
Yes, come.
Well, it's not much that I need to say. May I just show how the Commission, in the first instance, dealt with the appropriation bill issue. That's at page 208 of volume A1, volume 3A1. The bottom of page 208.
I'm saying additional to be given, additional to volume 1. Convenience of volume 3, 4. Yeah, the explanation of the consequences.
Rupees 35 basic. It is put to a 1 and they are not saying. So this one is going to take it 50. It's not like 4 rupees for honest. It becomes 4% of the
Plus page 208 of volume 3A1. The bottom of that page is where the discussion starts. 3 lines from the bottom of page 208. May I please close? What expenditure, last three lines of page 208, what expenditure shall be considered as expenditure charged on the Consolidated Fund of India has been stated in Article so-and-so of the Constitution and Article so-and-so of the Constitution, and shows that the annual financial statement or budget also to be covering sums required to meet other expenditure proposed to be made from the Consolidated Fund of India. Approvals of such expenditure which is not charged upon the Consolidated Fund of India through an Appropriation Bill Act under Article 114 of the Constitution of India will not make the sum required to meet the expenditure under any administrative scheme impress a legislative character on the scheme itself. This is the finding. The nature of the scheme under an executive order is in exercise of executive power under Article 73, and the authorization of the expenditure for carrying out such scheme under a parliamentary legislation are two different and distinct things, and the administrative scheme still remaining as an administrative scheme even after any legislative approval of the expenditure for its implementation cannot override the legislation or subordinate legislation made in exercise of the delegated power to make subordinate legislation under the statute. Hence, regulation should prevail. This millage was taken up before the appellate forum, but the appellate forum does not answer this question and says that we are a statutory body under the statute. This is not a 226 court. So this cannot be gone into the statutory forum. We have other reasons to say that the exercise of jurisdiction by the commission was wrong. And that is because, millets, kindly see how the commission proceeds. They do not tinker with the tariff order. The tariff order, millets, the two tariff order of 2015 and 16. Now, this petition is filed in the end of 2017, after the PPAs have been executed. Tariff orders 15, tariff order 16, based on which projects are commissioned, PPAs executed. Power starts flowing, then the commission's jurisdiction is invoked. Now, millets, the commission says in the same document, millets, kindly see page 211. This is the commission's order. I just want to point out few of the paragraphs how the commission interfered with existing PPAs. Kindly see page 211, about 6 lines from the top of that page. Sentence starting. This is the order of the commission, millets, which I'm reading, 28/7/2018. About 6-7 lines from the top. Thus, the sentence starting with thus. Thus, while the petitioners are not stopped by their conduct of seeking relief herein, the question of any review or amendment of earlier tariff orders does not arise in granting relief, which only amount to giving effect to clause 20 of the regulation in respect of the generation-based incentive, which no way interferes with determination of tariff earlier, except making such tariffs subject to generation-based incentive being factored into it. Then, millets, they do not. Kindly see the next page. I'm not reading everything, millets. 212, para 54, about 10 lines, 12 lines from the top. Sentence starting, there is no doubt.
Page
212, para 54, about 12 lines, 14 lines from the top, sentence starting, there is no doubt. There is no doubt that the tariff orders dated 1/8/15 and 26/3/16 have become final in the absence of any challenge by any stakeholder. But what is sought herein is to factor GBI into tariff, which was not the subject matter of consideration in the earlier tariff orders. The omission by the Commission to consider the same being now found in violation of Clause 20 of Regulation 1 of 2015. If revision of tariff is admittedly within the jurisdiction of the Commission, it will not tantamount to unsettling the earlier tariff orders or reopening any settled question, but only amounts to taking into consideration facts and circumstances as mandated by law, which ought to have been taken into consideration, but not taken into consideration. So, finally, they hold that this was an inadvertent omission. And this is being held after a tariff order in 2012 is passed, when the GBI scheme was introduced in 2009. In 2012, the tariff order is passed. The DISCOMs raise the issue of GBI. The tariff order notices that and ignores it. Then, Millets, after the tariff order.
This order is talking about, is this order which you are reading now?
Yes, Millets.
Dated what?
This is dated 28/7/2018. And if your lordship comes to page 218, this is how they
Even at the time when 2018 order is passed, the GBI is still continuing.
Yes, Millets. Kindly see, Millets.
And then the consequence of this order is to unsettle the position which had already been taken by virtue of the previous tariff orders.
And acted upon by PPAs, blessed by the Commission. Kindly see page 218, how they say an inadvertent omission to give effect to clause 20. This is what the appellate forum found. It can't be inadvertent. You were put to notice, not once, twice. Once in 2012, when you noticed the GBI scheme, and Millets, this is a sector regulator. They have a forum of regulators, statutorily, under the Act. So these schemes are discussed.
What is the solution in a case, in a situation where the regulator ignores by mistake
Yes, Millets.
a particular factor
Yes,
in
please.
fixation of tariff?
Yes, Millets.
So what happens to the previous tariff orders?
Millets, there is a process
What is
by which you can file a review, you can file an appeal against a tariff order. These are now not legislative in nature.
So your argument is that you can't touch it without a review.
Correct, Millets.
That is twofold argument. One is that this is not a review, and second is that this subsequent variation in 2018 will have the effect of retrospectively modifying
Modifying tariffs.
something which has
I'm
become
grateful.
final, which has happened. These are the 2 points.
Millets, one more submission that is the nature of the regulation. Millets, if your lordship knows that and your lordships in the JSW matter has seen the scheme of the Act. Now, under section 61, you come up with regulations which implements the provisions of the statute. Now,
See, you are all going on an overkill
I'll leave it at that.
when we were not inclined to interfere in all these findings, whether right or wrong, at any point of time. We are not here to revisit them. A question of law, the moment Mr. Dattar rose to
Yes,
you,
please.
was a broader question as to where does the central government's notification exist in the regulatory
Correct.
mechanism of the State Regulatory Commission, whether it has a binding nature or not. Because central government's role with respect to electricity fixation of tariff is nothing, zero,
Correct, Millets.
absolutely
Yes,
zero.
Millets.
There is no power of central government
Yes.
to pass anything because
Independent body.
even the state doesn't have.
Correct.
Only the regulator has the power with respect to tariff. Whether incentive is a aspect which will have a bearing on tariff, also we will take a broader view of the matter. We won't agree with Dr. Singhvi's argument that incentive is not a factor of tariff. Even assuming for a minute that if we take it into account that it is a part of tariff, regulators have the power to take into account. This incentive falls within the sweep of regulators' powers. Matter would have ended there. So therefore, the judgment had to be reversed if we had taken that line. Except that there is, we only thing is that we have to reconcile because these are not contradictory things. We told Mr. Datar also that the incentives given by the central government as well as the regulatory power of the regulatory commissions all work towards one common purpose, that is to ensure the health of the generators.
Renewable sector.
So they are renewable. And number one. Number two, we can add it up to say that it is an endeavor towards ensuring that there is a cleaner energy and there is an incentive. The clean energy is also a global warming issue which central government has taken initiative. So the commission will have the obligation to take into account the purpose and object of the incentive and give effect to it. It can't be that it is counterproductive nor it is subverted to something else. That much we would have definitely included and reconciled the central government's
Scheme.
thing. All other arguments are not relevant for us.
I'll leave it to it. Only one
For a
submission.
work kill, we are not
Yes.
going to touch that at all.
Well, one submission that under the statutory framework of the 2003 Act, renewable energy has a special mention on the promotional part,
We have seen it.
61E and 86.
We have seen that that's a ministry which is subsequently created.
Yes,
It's a new ministry. The new ministry has a very specific object in the context of
the MNRE.
climate change.
Yes.
And this court will take into account.
And these are linked with our international